Hi everyone, the theme of episode 4 is consistency in decision making. So what approach does a decision maker need to take towards previous decisions that it has made, or indeed that someone else has made? There have been several High Court and Court of Appeal judgments that have considered this point recently, so I thought that it might be helpful just to round up some of those. I'm going to start with the Court of Appeal decision in Cumberlege from 2018, where the Court of Appeal quashed a grant of planning permission for residential development in Newark because the Secretary of State had failed to take into account one of his own previous appeal decisions. What had happened was that in a decision letter dated the 19th of September 2016 relating to development in Ringmer, the Secretary of State had dismissed the appeal and held that policy CT1 of the local plan on settlement boundaries was up to date, so the tilted balance did not apply. Now, Ringmer and Newark are in the same local planning authority area, but in the Newark appeal decision on the 23rd of November 2016, 9 weeks later, the Secretary of State concluded that policy CT1 was out of date, and so the tilted balance did apply. And then in March 2017, the Secretary of State dismissed another appeal in the same local planning authority area and concluded that policy CT1 was up to date. Now, the Ringmer appeal decision had been issued after the close of the Newark inquiry, and no party in the Newark appeal had brought it to the Secretary of State's attention. But the Court of Appeal held that there will be cases in which it will be unreasonable and so unlawful for the Secretary of State not to have regard to a previous appeal decision, even if it has not been brought to his attention. The Court didn't attempt to limit the circumstances in which a previous decision can be a material consideration, but it gave as potential examples a decision relating to the same site, or to the same or a similar form of development on another site to which the same development plan policy relates, and also a previous decision relating to the interpretation or application of the same development plan policy. The Court of Appeal did not accept, however, that as a matter of law the Secretary of State ought to be aware of every previous decision taken in his name, so whether the Secretary of State has acted unlawfully will depend on the facts and circumstances of the particular case. In Davison, the facts were that planning permission was granted by the local planning authority for a new football and athletics stadium, but the planning permission was subsequently quashed by the High Court. The day after the High Court decision, the council granted planning permission on a second similar application, but the problem was that in granting the first planning permission, the council had concluded that the proposal would have an adverse impact on greenbelt openness, whereas in granting the second planning permission, the council concluded that the proposal would not have an adverse impact on greenbelt openness. Mrs Justice Thornton quashed the second planning permission. She confirmed that the principle of consistency is capable of applying to local authority decision making, so it's not just the Secretary of State. The key point to take from the decision, though, is that whilst a quashed decision is incapable of having any legal effect on the rights or duties of the parties to the proceedings, and the decision maker must start de novo, so with a clean sheet when redetermining the application, the quashed decision is capable in law of being a material consideration. So it might be a material consideration in the redetermination, but again it depends on the facts of the specific case. There's a really useful summary of the legal position at paragraph 56 of the judgment. The complaint in Irving was that the local planning authority's assessment of the extent of the public benefit that would result from the construction of the proposed house on the site was inconsistent with its assessment in other comparable applications for planning permission to erect a single dwelling house. There were 2 officer reports by different officers in relation to other sites in the council's area that had included identical reasoning on the very limited benefits of a single dwelling, but then the officer in relation to the decision under challenge had advised that a single new dwelling would have clear economic benefits. Mrs Justice Lang upheld the claimant's challenge. It's worth noting that the officer had referred to one of the 2 other sites in his report, and that Mrs Justice Lang concluded that the second site was a recent application for a similar development which he could reasonably have been expected to find out about. So local planning authorities need to ensure that their officers are aware of recent similar applications. In Tate, the local planning authority granted outline planning permission in 2016 for residential development. The local planning authority's officer had advised that applying the MPPF, the proposal was not inappropriate development in the Greenbelt because it fell under the exception for limited infilling in villages. The difficulty facing the local planning authority, though, was that back in 2009, an inspector had refused permission for similar development on the same site, concluding that it was not infill development. The officer in 2016 referred to the appeal decision and appended it to his report, but he failed to explain why he'd reached a different conclusion on the infill point to that reached by the inspector. There had been no material change in the situation on the ground since 2009. Lord Justice Lindblom held that whilst the Council's Planning Committee had not been bound to adopt the same approach as the inspector, if it took a different approach, it had to acknowledge that it was doing so and provide at least a brief explanation for the inconsistency, so the Council had erred in law. Finally, I'll just briefly mention Hallam Land. The Court of Appeal held that there was a fatal defect in the Secretary of State's decision in that he failed to engage with the conclusions on housing land supply that he had reached on 2 recent appeal decisions relating to the same local authority area. It's worth noting that in Hallam Land, the 2 previous appeal decisions had been brought to the Secretary of State's attention, and indeed representations had been made to him about them, but he didn't make any reference to them in his decision letter. Anyway, that's just a quick roundup of recent cases that have emphasised the importance of consistency in decision making. I hope it's helpful, and take care.